Imagine you are having a medical emergency.
Okay.
You're in immense pain, maybe your chest is totally tight, or in this specific case, your brain is actively working against you.
Right. A severe crisis.
Exactly. You are terrified. Your family is terrified. So you do what anyone would naturally do, right? You call for help.
You expect an ambulance.
You expect an ambulance to pull up. You expect paramedics with a stretcher, maybe a medical kit. But instead,
Instead, a police cruiser pulls up.
yes,
Uh-oh.
a police cruiser pulls up and out steps an officer with a pair of handcuffs.
It's a staggering image.
It really is. And for over a century, that wasn't some, hypothetical nightmare in India. That was the literal legal reality of experiencing a mental health crisis.
Yeah, it is a staggering image to start with, but it's entirely accurate.
Mm-hmm.
I mean, if your illness manifested in a way that, say, disrupted public order, or if the despair drove you to attempt to end your own life.
You weren't treated as a patient.
No, absolutely not. You were treated as a criminal suspect.
Wow. And that profound, just terrifying reality is the starting line for what we are exploring with you today. So welcome to another deep dive.
Glad to be here.
Today, we're unpacking what happens when a country decides to erase that entire century of criminalization and attempts to leapfrog straight into a utopian, human rights-centered future.
A massive leap.
Huge. We are diving deep into India's Mental Health Care Act of 2017. Now, on paper, this law is universally hailed as a gold standard.
Oh, absolutely.
It's considered this masterpiece of modern legislation that champions human dignity, autonomy, and the fundamental rights of the patient.
Right. The text itself is beautiful.
But here is the heartbreaking contradiction we are going to untangle today.
Mm.
While the law promises a sanctuary, recent human rights commissions are uncovering realities on the ground in government institutions that they literally describe as pathetic and inhuman.
It's perhaps the ultimate example of cognitive dissonance in modern governance, really. Yeah, because you have this legal framework that attempts to drag an entire society into the 21st century of human rights. But the physical infrastructure, the budget, and the deep-seated societal stigmas are still firmly anchored in the 19th century.
Right.
The gap between the text of the law and the reality of the hospital ward is just vast.
It's a chasm. And to figure out exactly how this happened, and honestly, more importantly, what this means for the millions of people caught in that gap, we are pulling from a massive stack of sources for you today.
We really dug into it.
We did. We're looking at comprehensive legal breakdowns from the Supreme Court and live law. We've got deep medical analyses from the Manipulan Journal of Nursing and Health Sciences, clinical perspectives from the International Journal of Indian Psychology, a really fascinating scoping review of how psychiatrists themselves view this law.
Which is very telling, by the way.
Oh, incredibly telling. And of course, the actual literal text of the Mental Health Care Act, the MHCA 2017.
Our mission today is to really trace this monumental shift. We want to understand how a massive nation moved away from a dark, prison-like approach to mental health care and tried to implement this revolutionary rights-based approach.
Exactly. So we're going to get into the weeds on how this law attempts to guarantee dignity, how it protects the mother-child bond, and how it finally decriminalized suicide.
Crucial points.
Yeah. And then we're going to critically investigate the massive failures in implementation because, understanding the law is only half the battle.
Right. Understanding why it's failing on the ground is where the real story lives.
Okay, let's unpack this. Because to really understand why the 2017 Act is considered such a revolutionary gold standard, we can't just look at the new law. We have to look at the dark system it replaced.
Exactly. You cannot appreciate the light without understanding the dark. And that previous system was governed primarily by the Mental Health Act of 1987.
The 87 Act.
Right. Now, the 1987 Act was rooted in what legal and medical scholars refer to as a custodial mechanism.
Custodial. Like a janitor or like a prison guard.
Very much the latter. It was a highly institutional, deeply paternalistic framework. Fundamentally, it viewed a person experiencing a severe mental illness not as a vulnerable patient in need of medical care, but as a potential danger to society.
Wow.
Yeah, the philosophical baseline was fear.
So the priority wasn't healing the person at all. The priority was protecting society from the person.
Precisely.
Yeah.
Under that old framework, the primary goal of the state wasn't rehabilitation, it was isolation. The state's job was basically to just remove the problem from the public square.
Just sweep them away.
Yeah. And you can see the visceral reality of this in a chilling historical detail we found in the source material from the National Human Rights Commission, the NHRC.
Oh, this part was wild.
They noted that historically in Delhi, the primary facility designated for persons with mental illness wasn't a hospital at all.
No.
It was a mental ward located inside Tihar jail.
Wait, Tihar jail, as in the massive maximum security prison complex?
Yes, the largest prison complex in South Asia.
That is just, it's unbelievable.
If you suffered a severe psychotic break in the capital city, you were sent to a prison. Furthermore, the people who ran these facilities were officially titled superintendents.
Which is a prison term.
Exactly. That is a term of penal administration, not medical care. The entire institutional model was custodial. And within those walls, treatments that we would now consider absolute human rights violations were just standard operating procedure.
Standard.
We are talking about the routine physical chaining of patients.
It is horrifying to conceptualize. I mean, think about your own life as a listener. Imagine your brain chemistry altering, betraying your sense of reality.
It's terrifying.
You are experiencing the most terrifying, confusing moment of your life, and society's response is to throw you in a jail cell and literally chain your body to a wall. It is medieval.
It was medieval. And if we connect this to the bigger picture, the catalyst for changing this wasn't necessarily, a sudden organic awakening of empathy within the domestic medical system.
Right. It didn't just happen on its own.
No, the real turning point was an international mandate. In 2007, India ratified the UN Convention on the Rights of Persons with Disabilities, often referred to as the UNCRPD.
Okay, an international treaty. But, I mean, we see countries sign UN treaties all the time and totally ignore them.
True.
Why did this one actually force a change?
Because of the way India's constitution interacts with international treaties it ratifies. By ratifying the UNCRPD, India took on a binding international and constitutional mandate to harmonize its domestic laws with the treaty's principles.
Ah, so they legally had to match it.
Exactly. The UNCRPD is incredibly clear. It demands a fundamental, non-negotiable shift away from that medical custodial model. It forced a philosophical pivot from treating a person as a problem to be locked away to legally recognizing them as a citizen with a health issue requiring social and medical intervention to function in society.
That is a massive paradigm shift. You're going from inmate to citizen.
Exactly.
It sounds like the old system treated mental illness as a crime to be punished, while the new system treats it as a broken bone to be set.
That's a great way to put it.
But I have to push back here a little bit.
Sure.
You can rewrite the legal definitions in Parliament all day long. But does changing the vocabulary in a statute actually change the deeply ingrained societal stigma? Like, if the average person on the street still views mental illness with fear and suspicion, does a new law actually change how a person is treated in their local community? Or does it just paint over the rust of a broken system?
That tension you just identified is the central nervous system of this entire deep dive. The law can absolutely mandate a rights-based approach, but if the cultural perception remains fearful and paternalistic, the implementation is going to face massive friction.
Right.
However, legal scholars argue that the law must change first to establish the new baseline of acceptable behavior. Before you can change culture, you have to revoke the state's legal permission to be cruel.
That makes sense. You have to take away the chains first.
Right. Because the MHCA 2017 now views these individuals as citizens with fundamental, inalienable rights. It had to start by entirely redefining how medical choices are made, especially during moments when a person's mind is actively working against them.
And that leads us directly into the actual text of the 2017 Act. And it does something incredibly fascinating right out of the gate. It creates a strict, impenetrable firewall between mental illness and unsoundness of mind. Because normally, colloquially, we just use those interchangeably, right?
And we do, but legally, conflating them is incredibly dangerous. According to the live law analysis under the MHCA, mental illness is now strictly defined by internationally accepted medical standards. Specifically, it relies on the World Health Organization's International Classification of Diseases, the ICD-10.
Okay, so mental illness is a purely clinical medical diagnosis made by a doctor based on a checklist of symptoms.
Correct. It is a health condition. But unsoundness of mind is an entirely different category.
How's
Well, the Act explicitly states that even if you have a severe medically diagnosed mental illness, schizophrenia, bipolar disorder, severe depression, you are not legally of unsound mind until a competent court officially declares you to be.
Why does that distinction matter so much? I mean, functionally.
Because historically, the moment you received a psychiatric diagnosis, society and the legal system often automatically stripped you of your agency.
Oh, wow.
They assumed you lacked the capacity to make any decisions for yourself. You couldn't manage your bank accounts. You couldn't sign a contract. You couldn't make choices about your own body.
Just immediately infantilized.
Exactly. The Supreme Court of India actually tackled this in a landmark case, Era v. State of NCT of Delhi. They reinforced a clear distinction between mental retardation, which relates to intelligence quotient, and a fixed mental age and mental illness.
Okay.
They established that having a mental illness does not automatically strip a person of their cognitive capacity to understand their rights or make decisions.
So the law assumes you are competent until a judge, not just a doctor, proves otherwise.
Yes. And the act goes even further to put up guardrails around what cannot be legally classified as a mental illness. It explicitly prohibits declaring someone mentally ill just because of their political status, their religious beliefs, or their nonconformity to moral or cultural values.
Which is a vital, historically necessary protection.
Yeah, explain that.
We have to remember that throughout history and across various authoritarian regimes, the field of psychiatry has been weaponized.
Oh, totally.
If a political dissident spoke out against the government, or if a person defied rigid social or sexual norms, the state wouldn't necessarily send them to prison. They would declare them insane and lock them in an asylum.
Right, because it discredits them.
Exactly. It was a way to discredit and silence people under the guise of medical treatment. The MHCA explicitly closes that door. Being a political rebel or a cultural nonconformist is not a disease.
Here's where it gets really interesting, though. Because the law now fiercely protects your capacity and assumes you have the right to make your own choices, it introduces what might be its most revolutionary tool.
Yeah. It's found in Section 5 of the Act, Advance Directives.
Advance directives are, without exaggeration, a profound show of respect for human personhood and autonomy.
They really are. And to explain how they work, the academic sources use this incredible analogy directly from literature. They call it the Ulysses Clause.
A great analogy.
Right. Think back to the Greek myth of Ulysses. He knew his ship was going to sail past the island of the Sirens. He knew their magical song would literally drive him mad, causing him to steer his ship into the rocks and kill everyone.
He foresaw the crisis.
Exactly.
Right.
He knew he was going to temporarily lose his mind. So while he was still sane, while he still had capacity, he instructed his crew to tie him to the mast of the ship.
Right.
And he gave them a strict order. No matter how much I beg, no matter how much I scream or demand to be untied later when I am under the spell, you must ignore me. Follow my past orders, not my present madness.
It is the perfect mechanical metaphor for how this works in modern psychiatry.
Yeah.
Yeah. An advance directive allows an individual, while they are healthy and have full mental capacity, to legally dictate their future treatment preferences.
So they write it down beforehand.
Exactly. They can explicitly state which medications work for them, and crucially, they can explicitly state their refusals for certain treatments, like electroconvulsive therapy, for example.
Oh, wow.
They can do this for a future time when they might suffer a relapse and lose that capacity. They can also officially nominate a representative, a trusted person, to make decisions on their behalf if they are incapacitated.
And the Supreme Court backed this up entirely. In a case called Common Cause v. Union of India, the court stated that the sacred right to a life with dignity is realized precisely through these kinds of directives.
Absolutely.
But okay, I have to play devil's advocate here.
Go for it.
As a listener, imagine you write out this Ulysses Pact. You write down, under no circumstances give me medication X. And you put that piece of paper in your desk drawer. 6 months later, you have an acute psychotic break at 2:00 a.m. in a completely different city. You are brought into an emergency room. How in the world does that ER doctor know your desk drawer directive even exists? I mean, how practical is this in the chaos of a real medical emergency?
That is the exact logistical friction point the law attempts to solve. And it does so by moving away from paper in desk drawers.
Good.
The Act mandates that these directives cannot merely be oral wishes spoken to a family member. They must be formalized in writing. But more importantly, Section 91 of the Act mandates that the mental health review boards maintain a centralized online registry of all advance directives.
Okay, so it's a digitized national database.
Exactly. The intended mechanism is that any treating medical officer anywhere in the country can log into the central database to verify if an advance directive exists for the patient sitting in front of them.
That's smart.
And here is the kicker. The law makes it the binding legal duty of the medical officer to follow that directive.
Wow, binding.
Yes. If a doctor, or even a well-meaning family member, wants to go against the Advance Directive, say they think a refused treatment is now absolutely necessary, they can't just ignore the document.
What do they do?
They have to formally apply to a quasi-judicial body, the Mental Health Review Board, to have the directive legally reviewed, altered, or canceled. The doctor's authority is subordinate to the patient's past, sane choices.
But there is a massive catch, right? The live law legal analysis points out a specific flaw, a major limitation to this autonomy when push comes to shove.
Yes, and it's a fascinating two-part problem. First, there is an actual drafting error in the legislation itself.
Wait, a typo in a national law?
Quite literally.
Yeah.
Section 5, which outlines advance directives, states that emergency care covered by Section 103 is exempt from these directives.
Okay.
But if you flip to Section 103 of the Act, it is actually about the rights of prisoners.
What?
It has nothing to do with medical emergencies. The clause they meant to cite for emergency care is actually Section 94. It's a clerical copy-paste error in the drafting of the legislation.
It's like writing a constitution and accidentally copy-pasting the rules for a parking violation into the section on declaring war.
Exactly.
In a court of law, a typo isn't just a typo. It's a loophole that lawyers have to fight over.
Precisely. It creates immense confusion on the ground. But moving past the typo, the more substantive issue is the policy exception itself.
Right, the emergency exception.
Yes. An advance directive is legally suspended during times of acute emergency treatment. If you are brought into an ER and the doctors deem it an absolute emergency, meaning immediate intervention is required to prevent death, irreversible harm to yourself, or serious harm to others, they are legally allowed to administer treatment for up to 72 hours without adhering to your directive.
So Ulysses can still be untied by the crew if the crew suddenly decides the ropes are cutting off his circulation and might kill him.
That's a great way to put it. The state still retains a fundamental overriding duty to preserve human life. That duty temporarily overrides your autonomy in an immediate life or death crisis.
Makes sense.
However, the law is strict. Once that 72-hour emergency stabilization window closes, the advance directive snaps back into effect, and it must be honored for all ongoing treatment.
Got it. So if the first major pillar of this law is redefining illness and giving you the power to make your own choices, the second pillar is dictating exactly how you must be treated physically once you are in the system.
Right.
And we are talking about targeting some of the most vulnerable, raw moments of human life. So if the law bans physical restraints and assumes capacity, how does it handle the daily physical reality of being in a psychiatric ward? Let's look at Section 20, which is explicitly titled The Right to Dignity.
When you read Section 20, it reads almost like a direct, point-by-point rebuttal to the horrors uncovered by human rights commissions over the previous decades.
Yeah, it's very specific.
It legally guarantees a safe, hygienic environment and the provision of proper, clean clothing.
Which seems so basic, but the fact that it has to be legislated tells you everything you need to know about the past.
Yes, unfortunately.
It explicitly bans compulsory tonsuring, which is the forced shaving of a patient's head. And it bans forcing patients to wear institutional uniforms. And then, under Section 95, it drops the hammer. It absolutely, unequivocally prohibits chaining in any form whatsoever.
You have to ask why those specific practices were so widespread that a national law had to single them out.
Right. Why were they doing it?
Well, shaving a person's head was often justified under the guise of hygiene, to prevent lice in overcrowded wards. Uniforms were justified for security, to easily identify patients. Chaining was justified for control.
But really, it's about something else.
Exactly. The psychological mechanism behind all of these is dehumanization. When you shave someone's head and put them in a nameless uniform, you strip them of their individual identity.
You erase who they are.
Yes. They're no longer a person, they are an inmate. They are an object to be managed. Banning these practices is the law stating that the loss of mental health does not mean the forfeiture of human identity.
It's about insisting that the person inside the illness is still there. And the law takes that philosophy of preserving humanity and applies it to the family unit in a really beautiful, delicate way.
Section 21.
Yeah, Section 21 deals with mother-child care. It states that a child under 3 years old cannot ordinarily be separated from a mother who is receiving care in a mental health establishment.
This is a profound recognition of developmental psychology.
How so?
Preserving the maternal bond during those first 3 years is vital for the neurological and emotional development of the child. And equally, it is often deeply therapeutically important for the recovery of the mother. Removing a child can trigger a massive exacerbation of psychiatric symptoms.
But hold on. Let's look at the reality of a psychiatric ward.
Okay.
What if the mother is experiencing a severe psychotic episode? What if she's experiencing delusions that make her a physical danger to that infant? I mean, you can't just leave a baby in a dangerous situation for the sake of a bond.
The drafters of the law anticipated that exact scenario. Separation can absolutely occur, but the mechanism is completely flipped from the old system.
Flipped how?
Under the old system, separation was the default upon admission.
Oh, just automatic.
Yes, under the 2010 Act, separation can only occur if a treating psychiatrist explicitly examines the situation and determines there is an active, present risk of harm to the child.
So the burden of proof is on the state.
Exactly.
The state has to prove why they should be separated, rather than a severely ill mother having to somehow prove she is sane enough to keep her baby.
Exactly. And even if separation is deemed medically necessary, it is not a permanent, unappealable decision.
Okay, good.
The law mandates that the separation must be formally reviewed every 15 days.
Every 15 days, that's frequent.
It has to be. If the separation lasts for more than 30 days, it escalates. It has to be reviewed and approved by the state mental health authority. The default setting is unity. Separation requires active, ongoing, documented medical justification.
What's fascinating here is how the law is trying to walk a tightrope, balancing the absolute right to dignity and family life with the practical, sometimes dangerous realities of severe psychiatric symptoms.
It's a very difficult balance, but a necessary one.
And speaking of the dangerous realities of psychiatric symptoms, we have to tackle what is arguably the most famous, most publicized part of this entire act. Section 115.
The decriminalization of suicide.
Right.
This section represents a monumental historic shift in Indian jurisprudence. To understand its impact, you have to know that for over a century, under Section 309 of the Indian Penal Code, attempting to commit suicide was a criminal offense.
A crime.
Yes. If you survived a suicide attempt, you could be punished by up to 1 year in prison, a fine, or both.
It is logically and morally counterintuitive. Think about it. You are in so much despair, so your internal pain is so overwhelming that you try to end your own life. You survive, and society's response to your unbearable suffering is to lock you in a cage and give you a criminal record.
The Law Commission of India recognized this absurdity years ago. In multiple reports, they noted that punishing someone for attempting suicide was essentially a double punishment.
A double punishment, yeah.
You are inflicting penal suffering on a person who is already drowning in psychological pain. It is the ultimate failure of empathy.
So mechanically, how did the Mental Health Care Act fix this? Because you can't just erase a century of penal code with a new healthcare bill. How did they legally justify taking jurisdiction away from the police?
They did it through a very clever legal mechanism. They created a statutory presumption.
A presumption.
Yes. Section 115 of the MHCA states that any person who attempts suicide shall be presumed, unless proved otherwise, to have severe stress.
Okay.
And because the law presumes they are operating under severe stress, it dictates that they shall not be tried and punished under Section 309 of the Penal Code.
Oh, I see. It essentially nullifies the criminal intent.
Exactly. It moves the act of attempted suicide out of the realm of criminal justice and squarely into the realm of public health.
That's huge.
It is. Furthermore, it mandates that the government has a duty to provide care, treatment, and rehabilitation to a person who has attempted suicide to reduce the risk of recurrence.
That sounds incredible on paper, but this is where the sources throw a massive bucket of cold water on the celebration.
Yeah, the reality is stark.
Both the live law legal analysis and the clinical analysis from the Manipul Journal point out a gaping hole in how this is actually playing out in reality. They report that police are still, years after this law was passed, wrongly booking survivors under IPC 309.
It's true.
They are still slapping a medico-legal stamp on hospital records. So my question is why? Is this a lack of central government funding to retrain officers? Is it deliberate defiance? I mean, if the police haven't read the memo, does this protection actually exist for you and me?
This raises a critical systemic point about the limits of legislation. Passing a bill in the echoing halls of Parliament does not magically rewrite the operating procedures of thousands of local rural police stations unless there is a massive, coordinated, heavily funded effort to retrain and sensitize law enforcement.
Right, they just keep doing what they've always done.
Exactly. When an attempted suicide happens, hospitals are historically conditioned to inform the police, viewing it as an unnatural injury. The police visit the hospital, they question the traumatized family, and often, out of sheer bureaucratic habit or complete ignorance of the 2017 Act, they file criminal charges under the old penal code.
But that defeats the entire underlying purpose of the reform. The Manipul Journal points out that decriminalization wasn't just about keeping people out of jail. It was supposed to reduce the stigma.
Yes,
It
absolutely.
was supposed to signal to people who are actively suicidal that it is safe to come forward, to call a hotline, to ask for help without the terror of being arrested. If the police are still showing up in the emergency room with handcuffs and clipboards, that terror remains completely intact.
Precisely. That medico-legal stamp on a hospital file is devastating. It means the patient's most vulnerable moment is now entangled with the criminal justice system.
Which is the last thing they need.
It destroys confidentiality. It exacerbates the family's shame. It proves that changing the text of a law is merely step one. Changing the bureaucratic machinery and the cultural reflexes of the state is step two, and it is vastly more difficult and slower.
And this failure of the police to understand the new suicide laws perfectly bridges into another massive, dark topic we need to explore. We need to look at the broader, often tragic intersection of mental illness and the criminal justice system as a whole.
A very dark intersection.
Because if the police are still the first responders to mental health crises, a lot of sick people are ending up behind bars.
The criminal justice system is, by its very design, uniquely ill-equipped to handle mental illness. It is built to punish culpability, not treat pathology.
Right.
Yet, historically and globally, prisons have been used as the default holding pens for individuals that the medical system has failed to catch or treat.
The statistics surrounding this are incredibly grim. According to the Live Law analysis, mentally ill prisoners are one of the most vulnerable demographics in the country. They are twice as likely to commit suicide as the general prison population.
Twice as likely. And we have to acknowledge that it is often the prison environment itself that acts as an incubator or a pressure cooker for psychiatric distress.
You mean the prison causes it?
Often, yes.
Yeah.
Organizations like the World Health Organization and the International Red Cross have extensively documented how factors inherent to incarceration, severe overcrowding, sensory deprivation, extreme isolation, the constant threat of violence, and a total lack of privacy breed what is called post-conviction mental illness.
Wow.
You can enter a prison system perfectly healthy and neurologically typical and develop severe chronic psychiatric disorders purely due to the trauma of the environment.
So, mechanically, what protections actually exist for someone navigating the criminal justice system if their brain is failing them?
There are a few key legal shields built into Indian law. First, at the level of culpability, you have Section 84 of the Indian Penal Code. This provides the defense of legal insanity, largely based on the old British Monotony rules.
Okay, what does that mean in plain English?
It essentially states that a person cannot be held criminally liable if, at the exact time they committed the act, they were incapable of knowing the nature of their act, or that it was wrong or contrary to law due to an unsoundness of mind.
But proving what a person's cognitive state was at the exact millisecond a crime occurred months or years ago seems incredibly difficult.
It is notoriously difficult to prove in court. Then, moving past the crime itself, you have procedural protections during the trial. Sections 328 through 339 of the Criminal Procedure Code, or CRPC, dictate how a trial must proceed if the accused is suspected to be of unsound mind.
Okay, translate this CRPC for us. What does that actually do?
Think of the Criminal Procedure Code in this context as putting up a giant stop sign in the courtroom.
A stop sign.
Yes. The fundamental premise of a fair trial is that the defendant must be able to understand the charges against them and assist in their own defense. If their brain cannot comprehend the gavel dropping or why the prosecutor is speaking, the trial cannot legally proceed.
So they just pause it.
The proceedings must be postponed until the person has recovered enough capacity to stand trial.
Okay, so that covers the Penal Code and the Procedure Code, but what about the MHCA 2017? Does this new healthcare law have the jurisdiction to reach inside the walls of a prison?
It does, very directly. Section 103 of the MHCA explicitly bridges this gap. It mandates that the government must establish a dedicated psychiatric ward in the medical wing of at least one prison in every state and union territory.
At least one.
Yes. Furthermore, it states that if a prisoner requires psychiatric care that the prison facilities simply cannot provide, the law allows for their transfer out of the prison and into a proper mental health hospital.
And the judiciary has had to step in aggressively to enforce this, right? The sources highlight the case of Reena Banerjee v. GNCT Delhi.
A very important case.
This was a landmark moment where the Delhi High Court looked at the situation and explicitly ruled that jails are not and cannot be substitutes for mental hospitals. They ordered the government to physically shift mentally ill prisoners out of jails and into actual healthcare institutions.
And we see the judiciary intervening at the absolute highest stakes possible, involving life and death. In the case of Shatrughan Chauhan v. Union of India, the Supreme Court made a profound ruling.
What did they say?
They declared that executing a death row convict who has developed a mental illness while awaiting execution violates Article 21 of the Constitution, which guarantees the right to life.
Wow.
They officially acknowledged the profound psychological torture of death row syndrome, the insanity that sets in from years of anticipating your own state-sanctioned death.
So we have the penal code protections, we have the CRPC stop signs, we have Section 103 of the MHCA demanding hospital transfers, we have Supreme Court rulings. The laws are on the books in bold print. But then the sources note that despite all of this, accused individuals with mental illnesses are routinely held in police custody or judicial remand for agonizingly long periods without a trial, directly violating their constitutional rights.
It happens constantly.
We are still using prisons as holding pens. It's like using a meat locker as a greenhouse. It's the wrong environment, the wrong temperature, and the wrong tools, and whatever you put in there is going to wither and die.
That's a devastatingly accurate analogy.
If the law unequivocally says they must be moved to hospitals, where exactly is the mechanism breaking down?
The mechanism is breaking down at the most fundamental level of reality.
Mm.
The hospitals they're supposed to be transferred to simply do not exist in the numbers required.
They don't exist.
And that answer brings us to the core tragedy, the absolute heart of this deep dive. We have to confront the massive, devastating chasm between the utopian, beautifully written text of the MHCA 2017 and the dystopian reality on the ground.
This is where we need to take a hard reality check. Let's look at the sheer mathematics of the crisis. The sources cite data from the National Mental Health Survey. They estimate that nearly 150 million Indians actively require mental health interventions.
Let's pause on that number. 150 million people.
It's mess.
That is roughly 10% of the entire population of the country. It is a demographic larger than the populations of many major nations.
But the tragedy is in the gap. Of those 150 million people who need help, only about 10% actually receive any intervention whatsoever.
Only 10%.
The sources detail an 83% treatment gap for general mental disorders and an astonishing 90% treatment gap for substance use disorders.
The scale of that unmet need is almost impossible to comprehend. Millions of people are navigating severe psychological distress completely alone. And when you look at the infrastructure meant to service that massive need, the numbers become even more alarming.
Let's hear the numbers.
According to the WHO Mental Health Atlas cited in the research, India has roughly 0.3 psychiatrists per 100,000 people.
0.3. Not even one full psychiatrist for a town of 100,000 people.
Exactly. The desirable ratio recommended by experts is at least 3 per 100,000. So the psychiatric workforce is operating at a tiny fraction of what is minimally required. Furthermore, there are fewer than 50 mental hospitals to serve a population of 1.4 billion people.
Wow. We built a multi-million-dollar state-of-the-art sports car with this 2017 act. We put leather seats in it, we gave it a V8 engine of human rights, but we completely forgot to build any roads to drive it on, and we have no gas to put in the tank.
The sports car is just sitting in the driveway.
And the human consequences of this lack of infrastructure are devastating. To understand this, we have to talk about the National Human Rights Commission report. The NHRC recently deployed teams to conduct visits to 46 government mental health care institutions across the country.
And we must remember, these are the exact, specific government institutions tasked by the 2017 Act with upholding the dignity, the hygiene, and the rights we just spent the last half hour discussing.
Right. These are the supposed sanctuaries. And what did the full commission find? They were so appalled that they issued formal notices to the Union Health Secretary, the Chief Secretaries of States, and the directors of these institutions.
They had to intervene.
Why? Because they found conditions that they explicitly described as pathetic and inhuman handling of patients. But out of all the horrors they documented, the one that stopped me in my tracks was this: the illegal detention of cured patients.
It is the most glaring, tragic violation highlighted in the entire report.
Wait, stop. We need to explain this slowly because it is so counterintuitive. Cured patients. You mean people who no longer have an active mental illness, who have been treated, are actively locked inside government mental hospitals.
Exactly, for months, sometimes for years.
How does a cured patient become a prisoner? Walk me through the timeline of how this happens.
It is a catastrophic failure of both family support and state infrastructure. Under Section 19 of the MHCA, every person has a fundamental right to community living. The law explicitly states that a person cannot be kept in a mental health establishment merely because they don't have a family to return to or because they are homeless.
Makes sense.
If they are abandoned, the government is legally mandated to provide support, including building transitional halfway homes to reintegrate them back into society.
Okay, so a patient gets sick. Their family, overwhelmed by the illness, brings them to the government hospital. The hospital actually does its job. The doctors treat the patient.
Right.
The patient stabilizes. They are clinically cured or at least managed to the point of being ready for discharge. The doctor calls the family to come pick them up.
And the family refuses.
Refuses.
Often due to the intense lingering social stigma of having a relative who's in a mental asylum, or simply due to the crushing economic burden of caring for them, the family abandons the patient. They change their phone numbers. They move.
So the patient is just stranded. But the law says the hospital must release them to a halfway house.
Yes, but the NHRC found that state governments, by and large, simply haven't built the halfway homes.
Of course.
They haven't funded the community reintegration programs. So the hospital administrator is sitting there with a cured patient, no family to take them, and no halfway house to send them to.
What do?
If they release them to the street, the person might starve or relapse immediately. So out of a twisted sense of necessity, the hospital simply keeps the cured patient locked up in the ward with the actively ill patients.
They are essentially serving a life sentence for getting sick, even after they've recovered. It is a complete, devastating violation of their Article 21 rights to life and liberty.
It's heartbreaking.
The NHRC noted that the regulatory bodies meant to prevent the state mental health authorities and the mental health review boards are either non-existent or barely functional in most states.
It is a systemic, nationwide failure driven by one very simple, very old problem: a chronic, severe lack of funding.
More money.
Always money. The sources vary slightly on the exact decimal, but India spends roughly 1% to 1.3% of its total health budget on mental health.
And what is the international standard?
The World Health Organization recommends spending at least 5% of the health budget on mental health. So India is spending a fraction of what is needed.
Wow.
The Mental Health Care Act is an incredibly ambitious, beautiful law, but it is fundamentally an unfunded mandate.
Unfunded mandate.
Yes. It legally demands world-class infrastructure. It demands complex online registries for advance directives. It demands staffed review boards in every district. It demands free treatment for everyone below the poverty line. But it provides almost no clear strategy or centralized budget allocation to actually pay for any of it.
The Live Law article makes a really sharp, counterintuitive critique about this. They point out that the Act demands heavy red tapeism to protect human rights.
Right, lots of bureaucracy.
It requires incredibly strict registration protocols for mental health care facilities, massive amounts of paperwork, and constant regulatory audits. Now, in a wealthy country, that's just good oversight.
Sure.
But in a resource-starved country where there are only 50 hospitals, doesn't this just harass and bankrupt the few private providers that actually exist?
It absolutely can.
If a small, well-meaning clinic is spending 40% of its budget and time just trying to comply with the massive regulatory burden of the 2017 Act, they have fewer resources, less time, and less money to actually treat the 150 million people standing outside their door.
That is a highly valid, pragmatic critique. Regulation without resources doesn't improve the system. It often just strangles the fragile system that already exists. It disincentivizes doctors from opening clinics because the legal liability and bureaucratic headache are simply too high.
So what does this all mean for the doctors who are actually in the trenches? Given this massive lack of infrastructure, the impossible patient loads, and the heavy regulations, it's no wonder that the very people tasked with executing this law, the psychiatrists, have serious reservations.
Oh, they do?
To understand their perspective, we looked at a fascinating scoping review published on PubMed. It analyzed how Indian psychiatrists perceive the 2017 Act.
This was a very illuminating review. The researchers analyzed 33 different manuscripts, mostly opinion pieces and studies published in the Indian Journal of Psychiatry, to map out the critiques coming directly from the medical frontline.
And what did they find?
They identified 7 main themes of criticism.
Let's unpack the big ones. First, they cite feasibility challenges. We just thoroughly covered that you can't mandate world-class care without funding it. They also cite clinical apprehensions and ideological reservations.
Right.
But the one that stood out to me was a deep mistrust toward the psychiatrists embedded within the law's heavy regulations.
Yeah, that's a big point of contention.
It seems the doctors feel the law was written with the assumption that psychiatrists are the bad guys who want to needlessly chain people up, rather than desperate professionals trying to triage care in a broken, underfunded system.
It's important to understand the genesis of the law to understand that friction. The MHCA was heavily influenced by human rights lawyers, activists, and survivors of psychiatric abuse.
Which is valid.
And their influence was absolutely necessary to break the deeply entrenched abusive custodial mindset we discussed earlier. But from the perspective of many clinical psychiatrists, they feel the pendulum swung so far toward prioritizing legal autonomy and rights-based ideology that it completely ignored clinical medical realities.
They feel hamstrung.
Exactly. And they feel they are being legislated into a corner where they can't effectively treat severe illnesses because they are drowning in legal compliance.
But perhaps the most profound, most culturally significant criticism identified in the review is the law's total neglect of the family caregiver.
This is a massive cultural blind spot.
Huge.
In India, the concept of the individual is deeply intertwined with the family. And in the context of healthcare, families are the dominant workforce. Because there are only 0.3 psychiatrists per 100,000 people and almost no community nurses, the family does absolutely everything.
The family is the hospital.
Essentially, yes.
Yeah. They supervise the medication, they figure out how to physically transport a resistant patient to a clinic hundreds of miles away, they monitor for side effects, and they bear the entire crushing financial and emotional brunt of the illness, often for decades.
And yet, as the review points out, the MHCA treats the patient almost entirely as an isolated, independent individual.
Like they're just alone in the world.
Exactly.
Yeah.
By heavily copying Western, highly individualistic legal frameworks like the UNCRPD, the drafters of the MHCA largely ignored the local, culturally specific reality of the Indian subcontinent.
How so?
In Western nations, the state provides a massive, funded social safety net. If a patient is discharged, there are social workers, state-funded halfway homes, and disability checks.
Right.
In India, the state safety net is full of holes. The family unit is the safety net.
The scoping review points out that the MHCA actually makes it difficult for family members to reside with hospitalized patients or be deeply involved in certain decision-making processes if the patient, in a moment of distress, pushes them away.
Yes, it creates barriers.
It makes you ask, are we trying to force-fit a square peg into a round hole? The law treats the patient as a completely autonomous island, a lone sailor like Ulysses, but in reality, they are part of a deeply interconnected family ecosystem that is doing 90% of the heavy lifting.
It's a huge disconnect.
By rigidly enforcing Western individuality, did the law inadvertently hurt the patient by pushing the family, their only real support system, away?
This raises an important question about the translation of international human rights into local contexts. The law focused heavily on the individual's right to be free from family coercion, which, to be clear, is a very real and valid concern. Families can be abusive.
Of course.
But by designing a system that inherently views the family with suspicion, the law inadvertently interrupted the continuum of care.
Interesting.
If a family is alienated or pushed out of the hospital process, they are less educated and less prepared to care for the patient when that patient is inevitably discharged back to their home.
And then what happens?
This lack of preparation directly increases the likelihood of relapse, or, as we saw in the devastating NHRC report, it leads directly to the ultimate tragedy: abandonment.
Wow.
The law legislated rights for the patient, but failed to provide psychosocial support, training, or financial relief to the very people who are expected to provide the lifelong care.
It is a staggering oversight that shows the danger of importing laws without adapting them to the soil they are planted in.
Very well said.
So, as we wrap up this massive deep dive, let's summarize the incredible, turbulent journey we've been on with this legislation. We started in the dark, custodial days of the 1987 Act, a time when mental illness was treated as a public danger.
When patients were warehoused in prison wards at Tihar jail and literally chained to walls.
Then we saw how the ratification of the UN Convention on the Rights of Persons with Disabilities acted as a constitutional catalyst, forcing the state to abandon the custodial model and adopt a rights-based approach, recognizing the patient as a citizen.
Yes, a massive philosophical shift.
We unpacked the beautiful utopian guarantees written into the 2017 Mental Health Care Act. We saw the profound respect for human autonomy through the mechanism of Advance Directives, the Ulysses Clause.
And we saw the fierce protection of bodily dignity. the explicit banning of tonsuring, uniforms, and chaining.
We saw the careful legal mechanisms designed to preserve the mother-child bond, and we explored the historic, deeply necessary decriminalization of suicide, legally recognizing it as a cry for help caused by severe stress, not a crime to be punished by the state.
But we also had to confront the heartbreaking reality check on the ground.
Right.
The reality that police, due to bureaucratic inertia, are still making arrests for suicide attempts. The reality that the criminal justice system is still used as a holding pen, warehousing the mentally ill without trial because hospitals are full.
And the devastating NHRC findings that fully cured patients are living in forced captivity because the state hasn't funded the halfway homes it legally mandated, and their families have abandoned them.
The implementation gap is just tragic.
We built the sports car, but we didn't build the roads. Which leaves us with a final provocative thought to mull over.
I'm ready.
We've talked a lot about rights today, but if a fundamental right, like the right to community living or the right to emergency mental health care, is legally guaranteed by the state on a piece of paper, but the state refuses to allocate the budget to build the hospitals, hire the doctors, or train the police, does that right actually exist?
It is the ultimate question of jurisprudence versus reality. Is a human right simply a theoretical concept, a noble idea written in a statute? Or is a right, by definition, a tangible claim on society's resources?
Exactly.
If you have a right to care but no clinic exists within 100 miles, your right is practically meaningless.
Is a law without funding simply a beautifully written fiction? We encourage you to look around your own community, wherever you are listening from. Think about the infrastructure.
Pay attention to it.
How is a mental health crisis treated where you live? If you dial emergency services tonight, who shows up? Are there funded support systems or just lingering stigmas?
It's an important question to ask.
Because it is on all of us to recognize that passing a law is just the starting line. We have to advocate for the roads, the state funding, the psychiatric training, the community support for families to actually carry the weight of modern healthcare legislation.
Absolutely.
Because until that physical and financial foundation is built, the words on the page are just promises waiting to be kept.